Now, apart from the fundamental error of statism in general, additional errors are involved in the special case of a democratic state. A detailed treatment of this subject, again, has been provided by myself in another book of mine, Democracy, the God That Failed, but I want to make at least a brief mention on this. The traditional pre-modern state form is that of an absolute monarchy. Yet monarchies were faulted, in particular also by classical liberals such as Mises, for being incompatible with the basic principle of equality before the law. Monarchy instead rested, obviously, on personal privilege. Thus, the critics of monarchies argued the monarchical state had to be replaced by a democratic one. In opening participation and entry into state government to everyone on equal terms, not just to an hereditary class of nobles, it was thought that the principle of equality of all before the law had been satisfied. However, this democratic equality before the law is something entirely different than and incompatible with the idea of one universal law equally applicable to everyone, everywhere, and at all times. In fact, the objectionable schism and inequality of a higher law of kings versus a subordinate law of ordinary subjects is fully preserved under democracy in the separation of public versus private law and the supremacy of public law over private law. Under democracy, everyone is equal insofar as entry into government is open to all on equal terms. Everyone can become king, so to say, not only a privileged circle of people. Thus, in democracy, no personal privileges or privileged persons exist. However, functional privileges and privileged functions continue to exist. Public officials, as long as they act in an official capacity, are governed and protected by public law and occupy thereby a privileged position vis-à-vis persons acting under the mere authority of private law. In particular, public officials are permitted to finance or subsidize their own activities through taxes. That is, they do not, as every private law subject must, earn their income through the production and the subsequent sale of goods or services to voluntarily buying or not buying consumers. Rather, as public officials, they are permitted to engage in and live off what in private dealings between private law subjects is considered theft and stolen loot. Thus, privilege and legal discrimination and the distinction between rulers and subjects will not disappear under democracy. To the contrary, rather than being restricted to princes and nobles, under democracy, privileges will be available to everyone. Everyone can engage now in theft and live off stolen loot if only he becomes a public official. Predictably then, under democratic conditions, the tendency of every monopoly of ultimate decision-making to increase the price of justice and to lower its quality and substitute injustice for justice is not diminished, but is actually aggravated. As an hereditary monopolist, a king or a prince regards the territory and the people under his jurisdiction as his personal property and engages in the monopolistic exploitation of this property. Under democracy, monopoly and monopolistic exploitation do not disappear. Rather, what happens is simply this. Instead of a prince and a nobility who regard the country as their private property, a temporary and interchangeable caretaker is put in monopolistic charge of the country. The caretaker does not own the country, but as long as he is in office, he is permitted to use it to his and his protégés' advantage. He owns its current use, or what is called Usufruct, but he does not own its capital stock. This does not eliminate exploitation. To the contrary, it makes exploitation less calculating and carried out with little or no regard to the capital stock. Exploitation becomes short-sighted and capital consumption will be systematically promoted. Let me just give an example. I can give you a house and make you the owner of the house. Or I can make you a temporary caretaker of a house. For 4 years, you can try to get as much out of the house as you want. But you cannot pass it on as an inheritance. You cannot sell it in the market and so forth. Will you treat the house in a different way? Whether you are a private owner who can pass it on in the form of an inheritance, or will be you just a temporary caretaker who cannot pass it on, who cannot sell it in the market? And the answer should be clear as daylight, of course. If you are only a temporary caretaker of the house, you try to run down the capital, get as much out of it in as short a possible time as possible, whereas as a private owner, you will try to preserve the value of it in order to pass it on in some sort of intact form to the next generation. Democratic politicians are people who try to rob the country as quickly as possible because after 4 years they have no chance to rob anymore, or after 8 years, whatever the term is.